Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. In this video today, we will be discussing 5 important judgments from Indian Evidence Act, another topic that is Doctrine of Res Gestae. In the last video, I have started with the first topic of Indian Evidence Act, that is appreciation of evidence. अगर आपने वो वीडियो मिस कर दिया, I would suggest all of you to watch that video as well. Earlier to that, we have discussed Indian Penal Code, different judgments, 5 important judgment series मैंने exclusively start की है for the Central Bureau of Investigation APP examination. And yes, of course, don't forget to subscribe to our YouTube channel, that is Legal B, exclusively for law, discipline and law examinations. If you have any queries, you can reach out to us by writing us an email on hello@iexamb.com, call us on 92055 92408 or visit our website www.iexamb.com. Doctrine of Res Gestae, as covered under Section 6 of the Indian Evidence Act, talks about facts forming part of same transaction. So from that, the first judgment that we will be discussing is Indra versus State of HP 1989. In this case, it was held that a statement in order to be a part of res gestae must have been made substantially contemporaneous with the act or immediately after it, so that there is no opportunity for reduction or fabrication. It is in this background that the interval between the act and the statement assumes significance. So this case helps us understand the ingredients of this particular section very clearly, that if a statement has to be a part of same transaction, it should be spontaneous. There should not be any opportunity for any fabrication, addition or reduction. So ये ingredient इस particular case law से काफ़ी clear हो जाता है that substantially जो statements है वो spontaneously connected होनी चाहिए, contemporaneous होनी चाहिए और immediately it should be after that particular act. Only then it will be covered as a valid statement or a relevant fact under section 6. In no case the statement should be in the nature of a mere declaration or a narration of a past event. It should be a part of that incident itself. Second, Gentala Vijayavardhan Rao versus State of Andhra Pradesh 1996. In this case, it was held that the rationale in making certain statement of a fact admissible under Section 6 of the Evidence Act is an account of spontaneity and immediately after the statement of fact in relation to the fact in issue. So it should be related to the relevant fact or the fact in issue. This is also a very important element that we have to understand. If it is related to the fact in issue, only then it will be considered as a relevant fact. Even if it is a part of same transaction but has no connection with the fact in issue, then it will not be covered under Section 6 of the Act. But it is necessary that such fact or statement must be a part of the same transaction. So in other words, such statement must have been made contemporaneous with the acts which constitute the offense or at least immediately thereafter. There should not be a lot of space in time between the fact in issue, the occurrence of that act and the relevant fact. If there is an interval, then it should be slight and it should not cause any kind of fabrication in between, because that will break the relevancy of that particular fact under res gestae. Moving to the next case, Mahindra versus State of Madhya Pradesh 1975. In this case, it was held that a statement of a witness who had come to the spot of murder after the occurrence to the effect that the persons present there were saying that the accused had killed the deceased without indicating whether they had actually witnessed the murder is only a hearsay evidence and is not admissible under Section 6. So इस केस में ये clear हो जाता है that hearsay evidence is not going to be covered under Section 6. Somebody is just coming and narrating that the accused had killed the deceased without actually indicating where they had witnessed the murder, then that is merely a hearsay evidence. तो इसको हम res gestae के अंडर connect नहीं कर सकते. This is also something which we have to understand, that res gestae requires a concrete connection with that act and the witness should be present there. Hearsay evidence will not be able to come under Section 6. Jetharam versus State of Rajasthan 1979. In this case, certain witnesses stated that they not only saw but also relied on the version given by the other witnesses immediately after the occurrence that the accused was the assailant. It was held that even taking that the witnesses relied on the version given by the person at the scene immediately after the occurrence, it was admissible as a relevant fact under the Indian Evidence Act. So in this case, what has been talked about? The witnesses stated that they not only saw but also relied on the version that was given by other witnesses immediately after the occurrence that the accused was the assailant. Even if the witnesses relied on the version that was given by the other person, then also it was held admissible as a relevant fact under Evidence Act. Here court has taken a broader view because in previous case we have discussed that hearsay evidence is not covered under section 6, but in this case, since the person who is giving the version that the accused himself is the assailant was actually present in the scene of offense or the scene of incidents of murder, that is the reason that his statement has been considered as a valuable one. So if some other witness is relying on that statement and mentioning that before the court of law, it is made admissible under section 6. So here you have to understand the difference between this case and the previous case. Previous case there was only hearsay evidence and there was no person present at the scene of offense, but in this case the person is actually present at the scene of offense, the witness, and the statement that he is making is relied on somebody by somebody else. So that has to be very clear, and this thin line of difference should be clear to all of you. The last case, Ramdas versus State, 1972. In this case, a minor girl was abducted by the accused, and immediately on her recovery at the railway platform, she told her uncle that she had handed over all her ornaments to Ramdas, who had placed them in a jhola and had run away with the ornaments. So this was a simple statement who was the minor girl was making that, but still that statement was held relevant under section 6, and it was not affected by the minority of the girl, and it was not affected by anything because the concrete information that was gathered by her, because she had observed that at the place of incidents. So it is a part of same transaction and was held relevant under section 6 of the Indian Evidence Act. So now it is very clear to us that the basic ingredients of section 6 of the Indian Evidence Act, that is Doctrine of Res Gestae, is that the fact should form a part of same transaction. The person, the witness, should be present in the scene of offense, and it should be very much connected, spontaneous, immediately after the scene of incidents, but not having a time gap that much long that it is separating the entire fact and it is not at all connecting the relevant fact with the fact in issue. That should not be the case. I hope all these cases have helped you all a lot in understanding the concept of section 6. If you have any queries, you can reach out to us. आप इस वीडियो के कमेंट सेक्शन में भी लिख सकते हैं, and you can also reach out to us by any of the modes mentioned over here. Thank you everybody. Prepare 50% faster with us at iExamB. Thank you. Have a good day.